And tonight we're talking about something we all don't want to talk about, and that's estates and legacy planning. But it's inevitable, and there's some basic information we all need to know. We have three speakers this evening. The first will be a brief presentation from Miriam Adams, who's the head of dance collection Danse, which is a community organization in the dance community, which exists to work on legacy issues, ensuring that Canada's performing arts dance history is preserved. And so we thought it would be interesting to hear from Miriam a little bit about what they do. And then Ben Reale is back with us, and he will do the basics on wills and estate planning and so on. And then finally we have Elise Orenstein, who's a lawyer who does a lot of work in copyright. And of course, for artists, a big issue around estate and estate planning is what to do with one's copyright, which does exist after the artist is gone. And so Elise will talk specifically about copyright issues. So with that, Miriam, welcome.
Now I'm very short, and this is very high, so we'll just tilt us. Who said stand on your toes? I didn't bring the right shoes. I have those terrible shoes. Anyway, I have 10 minutes, so if I go over, you'll bring the cane and yeah. Just a quick little history here. I'm a former dancer. I danced with the National Ballet, graduated from the National Ballet School. I married the late Lawrence Adams. Lawrence passed away in 2003. When we left the National Ballet, we started a small group of students, essentially, and said, if you ever want to be a dancer, there were only two dance companies in Toronto, Toronto Dance Theatre and the National Ballet, you're going to have to create your own environment. So we started a little company, and we rented a theater, and they choreographed, and they made their own costumes and did their own audio recordings. We did that for a while. The group dwindled from 15 to 5, and we had a framing shop on Markham Street, and we moved it downtown to Britain, Queen and George, and we built a little theater, and everybody choreographed, and we had 41 seats in there. And after about a year, we said, okay, we're going to open this facility up to anybody who wants to perform. So we got people from across the country who are now well-known professional dance artists: Jean-Pierre Perrault, Marie Chouinard, Christopher House, David Earle. Lots of folks came through. I think there were about 135 choreographers who used the theater space. But what? It was called 15 Dance Laboratorium. We opened it in 74, just after our 15 Dancers group had dissolved. Anyway, we ran the theater for about 7 years, and while we were doing that, the 70s were sort of very hot times for dance. There were a lot of new companies starting, and a lot of independent artists were doing work, and I don't know how things happened, but we got hold of a video camera, and we were taping the performances. We were also part of an organization called the Dance in Canada Association, and we would have a conference in a different city every year, and we would tape interviews with people. I mean, how do you get these thoughts in your head? Anyway, little did we know that all this recording of information would lead to our current organization called Dance Collection Danse, which is an archives for Canadian dance history. But after we closed the theater, we built a television studio where we worked with theater people to advise them on how to make work for television. And we kind of ran out of money at that point, like everybody does. And we said, all right, now what are we going to do? So we opened the file drawer full of ideas, and we wrote up a proposal. We went to the Laidlaw Foundation, and we said we would like to do some research into Canada's theatrical dance history. Theatrical meaning not so much social dance or ballroom dance, but concert dance, dance for the stage. And knowing, because we had oral histories and videotapes of people like Gwyneth Lloyd and Betty Farrelly, who started the Winnipeg Ballet Club in 1938. We had all this already on tape. Anyway, we went to the Laidlaw Foundation. We put in this proposal. And I hope nobody here was on the board of the Laidlaw Foundation, because now I'm going to say something terrible. Are you?
No, you're fired.
Okay. Anyway, the board, they said, there's no Canadian dance history. It doesn't exist. Canadian dance started in 1951 when the National Ballet started. But we knew better because we've been talking to folks who had been working in earlier days. So we got some money, and we put together a project whereby we found creators in Canada who had been working, and this isn't so far back, but 30s and 40s when they had small dance companies and they were doing a lot of dance works. And we reconstructed, I have to look at my notes, the works of Nesta Tumeen, who had a company in Ottawa, Nancy Lima Dent, who did modern dance in Toronto. Again, we're talking 30s, 40s, 50s. Françoise Sullivan and Jeanne Renaud from Montreal. They were working in the 40s in Paris and New York and in Canada. And then, of course, Gwyneth Lloyd co-founded the Winnipeg Ballet, and Boris Volkoff, who had a school and a company in Toronto. He came to Canada in 1928. And we brought the original dancers in to assist, and we reconstructed these early works. We notated them. There's such a thing as dance notation, Benish notation, and Levan notation. It looks like a musical score, sort of. And we videotaped. So we said, all right, these are the benchmark works for Canadian choreographies. It's as far back as we could go. There was very little film. There was a little bit of film from the NFB. But that was really, and we worked from photographs. We chose works that had Canadian composers, Canadian set designers, and of course, Canadian choreographers. So we put those things together. We went to Expo. We did a show at the Canada Pavilion. And we raised a lot of money. There was money in the mid-'80s. And the government cared about heritage and legacy, and we sort of had an easy time, just for a couple of years in there, 85, 86. And we were able to hire lots of terrific performers and writers and technicians and stuff like that. Anyway, when it was all over, we said, all right, now what are we going to do? We have all this archival material because we had oral histories and photographs and some film clips. And it was suggested that we start an archives. How much time do I have? I have 2 minutes. All right. Yeah, but he's the boss, and he said 2, and I always do what I'm told. So, yeah, that's right. They say do this, and I do this, right? Anyway, so we started an archives, and the only way we could get the word out was to publish a little newsletter and send it around. We got all kinds of mailing lists. Send it around to the dance community to say, we're an archives, we have wonderful treasures. If you have things to donate, we'd be happy to take them. And essentially, we were on a rescue mission, because whenever we heard if anybody had passed away or wanted to throw something in the garbage, we said, don't throw it away, we'll take it, which is completely crazy, because now we have 5 locker spaces off-site, piled high to the ceiling with boxes, which we're, cataloging, but it takes a long time, and we work out of my home. We've been working out of my home for 26 years, which at my age is I want my bathroom back, you know what I mean? Anyway, so we started to publish a magazine, and then we started to publish books so we could show people that we do have a very deep history in this country, and we did an encyclopedia. And whoever answers the question gets this. The Canada Council actually helped us with this because they wanted something that they could show, and they could say to Canada House in London or wherever, Canada has a deep dance. And this is only a very small part of the whole history. It needs to be updated. So here's a present for somebody. Anyway, to date we've published 39 books, memoirs, biographies, cultural histories. We just released one last week in Montreal called Renegade Bodies, which is about dance in the 1970s. And we have hundreds of hours of oral histories on tape, and we have video records, and we have, 585,000 documents and paintings and books. And we're essentially now looking for a space where we can share, where we can do exhibits and lectures and have a video screening room where we can share all of this stuff. Okay, I'm finished.
What's the question?
That's the question. You were going to pose a question.
Oh, what's the question?
You said you had a question and whoever could answer.
All right, I have a question. Who's the mayor of Toronto? Who said Rob Ford? Wait, this is bilingual. So if you speak French, there's French in there. Good.
My daughter-in-law is ballerina, and
She'll love it.
Yeah, great.
Thank you very much, Miriam. Now, Elise Orenstein, who, in addition to being a lawyer and with expertise in copyright, is on the board of the Canadian Senior Artist Resource Network and also still on the board of the Artist Health Centre. So she's very active in our community. Elise.
So while my assistants are at work trying to bring the presentation up on screen, I'll just tell you what I plan to do. I'd like to provide a really basic overview of copyright law so you can understand its significance for estate planning. I want you to be able to identify the assets in the estate that actually attract copyright protection, how to determine whether they have sentimental value or real economic value, decide whether you want them to be destroyed or preserved, or if they haven't been published to date, published or made public later on, decide who will inherit them, decide who will protect your legacy, and prepare and plan. And because I have too many slides, I'm just going to start with some of the basics, and I'm actually going to skip to the practical points at the end of the presentation and try and work in the things that we can't really cover because of the time constraints. So what is copyright? It's a bundle of rights. Typically, it's divided into economic rights and moral rights. And the purpose is to enable the owner to control the way the copyrighted property is either exploited commercially and to protect the integrity of the work and the author's reputation in it. Author means any creator, whether it's a visual work or a literary work or a dramatic work, any kind of work. Copyright is interesting because it can be divided in time. You can give licenses for a limited duration. You can make the licenses exclusive, so only one party can enjoy the rights at one time. The rights can be non-exclusive, so more than one party could have the same rights in time or overlapping rights. And it can be transferred. It can be divided by geography. It can be very complex. And because people, in order to exploit the works to their fullest value, utilize all these different flexible arrangements around copyright, you can end up with a very complex trail of what's happened historically and what, in fact, is the state of your copyright on the time of when the mortal rights come in, as opposed to the moral rights. Copyright is different than tables and chairs. It attracts the works that attract copyright have to exhibit a minimum threshold of creativity and original labor. But for the purposes of estate planning, you do need to decide what is something that you think you want to preserve a heritage around or a legacy versus some minor doodlings or the instruction manual for the vacuum cleaner that you got paid to do. Or because things that I write can have copyright protection, but I'm not necessarily going to want to preserve them. I may want to destroy that to make it easier for my children, hopefully. So we're going to skip over the types of work that attract copyright because I think in this audience we understand that they're literary, they're dramatic, they're artistic. But I do want to just touch on digital assets. So you may have some of your own work that's actually on the internet or on your computer in computer files that are subject to a password. You may have, if you're a photographer, have works on Flickr. You may have published stuff on YouTube or on Facebook. And in terms of estate planning, if you have done that, there's a lot of complication around the executors retrieving those, what we call digital assets of your work, if they don't have the passwords and the usernames. So generally for estate planning, you should be putting a list together of all those things. Well, I know mine change all the time, but it's really important in terms of copyright planning. There's another kind of it's not copyright, but it attracts protection under the Copyright Act. They're called neighboring rights. And I don't know if any of you have ever heard that expression before. Gary has. And just so that you know, in case it does affect you, there are certain protections provided for a performer's performance, for example. A performer's performance could be a singer's interpretation of a musical number. So, as you know, right now, a composer gets royalty, will receive royalties every time his or her music is played. The record company will get a fee if CDs are sold, or etc. But the performer has actually been left out, and the thinking is that when Rubinstein played Chopin, he added some originality and some creativity, which enabled his records, his recordings to sell. So in some jurisdictions, not all, the performer's performance attracts extra royalties, and normally they're collected through collective societies. So if you're a composer, for instance, you will make sure in your estate that the executors understand that you may be receiving royalties, or you're registered with SOCAN or the other recording rights. All of those, right. But if you actually are a performer, and it could be of a dramatic work in a movie or TV show, or... No, not yet. But, okay, I'm wrong. Only the sound recording. So you will want to make sure that you leave a paper trail regarding what you've performed in. I'm ahead of myself. Moral rights. So what is the moral right? The moral right is different than the economic right. The moral right actually goes to preserving the integrity in the work, and it also enables the author, the creator, to be associated by name with the work, or to have his or her name withdrawn from the work, or to be anonymous. So the first example in Canada of a moral right that was actually approved was concerning Michael Snow's geese in the Eaton Centre. And the Eaton Centre put ribbons on the geese for Christmas, and Michael Snow said, no, that actually offends the integrity in my visual works. And he won. The right to be associated with the work, a famous case in the States, was when Robin Williams had his name removed from the movie Baron Munchausen's whatever it was, because he was disappointed in the script and didn't like his performance in it. Now, just so you know, with moral rights, in the European Union, they have very strong moral rights. Moral rights in the United States are limited to visual works only. So they're a little bit behind. In Canada, moral rights, we have a full spectrum of moral rights. Pardon me? No, we have a broader spectrum than the Americans, but the duration is a little bit different. Fair dealing, just generally, copyright is supposed to be a balance between the rights of the author or creator and the rights of the public to have access to those works. And it's really a government-granted monopoly which recognizes the original labor that goes into creating work, and it wants to encourage creators to reap the economic benefit from exploiting their works over a period of time. But once that period is over, then the public will have full access without payment. Now with the advent of the internet, there's huge fights going on between demands by users to have free access, and the copyright owners who want to be able to exploit those rights. But in terms of estate planning, you might want to consider on death whether you wish to make your works available for free or not to the public, or whether you wish the estate to continue administrating your estate for the period of copyright protection. So generally speaking, in Canada, the period of copyright protection in your estate is 50 years after the calendar year that you die. I know there's a more elegant way to say this. It's more elegantly stated in the Copyright Act. And that applies to moral rights as well. In other jurisdictions, the UK, the US, it's in the EU, it's 70 years. In fact, the extension of copyright protection in the US from 50 to 70 years was lobbied for and successfully granted because of Disney's efforts, because the copyright protection in Mickey Mouse was coming to an end. So it's actually called the Mickey Mouse Amendment. But it's interesting because the idea is that behind it is to enable at least the first two generations following death to reap some benefit from the work. And with people living longer, the rationale is that 50 years after death didn't really cover the first two generations. In Canada, it's after 50 years. In a lot of jurisdictions, it's 70. I think in Mexico, it's 75. It's actually in the slides, but we won't bother going into each and every one. Just another funny quirk in our Copyright Act is that some works may not be published by you, and the estate may find them. And until very recently in Canada, if a work was discovered that had never been published, whoever, the estate, let's say, could publish it, and then that work would enjoy 50 years of protection, even if it was found 100 years after the death of the author. But that's no longer the case. So in Canada, it's the term will be 50 years from the death of the author. So if let's say something is found 10 years after an author dies, there will only be, and published, there will only be 40 years of protection left. And so what some executors are doing is, rather than publishing the work in Canada first, they will publish it in the UK, where the protection period is 70 years. So that because of the bilateral laws, the estate gets the benefit of the 70 years. And that's something that the executors of copyright need to understand. Just another funny footnote, because it is such a quirky act, when it comes to photographs that have been made for a corporation, the corporation may very well be the owner. And the interesting thing is that the consensus amongst copyright lawyers is that the corporation will hold the moral rights in the photographs that it owns as well. Very quirky. It's one of the few jurisdictions where that actually occurs. Anyway, we talked about duration, and my note was nothing lasts forever unless it's on YouTube. So, another funny quirk in our Copyright Act, and then we'll get to the practical tips, is that we still have in Canada a reversionary interest in copyright after death. So I did say that the copyright in the work continues for 50 years after death, except in Canada, the last 25 years of copyright actually revert to the author's estate. So let me give you, and this is very unusual, and I'll tell you why this law came into effect and why it's not in effect in most jurisdictions. Let me go back. It came into effect because of Dickens. The intent was to relieve against hardship suffered by the impoverished family of the deceased, and so the feeling was, here's somebody who's became famous later in life, and the family is poor, and so therefore, even though Dickens may have assigned his publishing rights to whomever the publisher was, 25 years after death, those rights would revert to the family, and they could enjoy themselves the economic benefit. Or, in fact, upon death, the family could actually assign those rights for money to another publisher or the same publisher for the last 25 years of copyright in the estate. And the thinking was that at that time that artists are crazy, they can't manage their affairs, they need to protect the family. No, this is true. And it's very paternalistic. And that's not the thinking. And of course, this law has been repealed in the UK, where it originated, and in most other countries, but not in Canada, which is very interesting. And of course, there's lobbying in Canada. But, it has the reverse effect, because if you're the recipient, if you're buying an assignment of copyright, you're paying money to have copyright assigned to you, and you know that the last 25 years of the term are going to revert back to the estate, you're not going to value it. You're not going to pay the same consideration knowing that. It doesn't apply. The reversionary interest doesn't apply in some situations, and I'm not going to go through them because it's technical. Except that if is there anybody from Quebec here who's, because it's even worse in Quebec because it's it may catch marriages. It's very complex. But anyway, to get around this provision of the Act, your legal representatives can assign the reversionary interest back to the original assignee at any time during or after the first 25-year period. You can assign for the reversionary interest to belong to the original assignee in your will. You can bequeath the reversionary interest in your will. Or you can try to give the original assignee some kind of royalty-free license to publish the work or use the work for the last 25 years. And just so you know, it's very important because some estates have actually received a windfall. A lot of music was assigned to music companies, and then the music companies thought they had the rights to exploit the music for the full term of copyright, and then they were pretty surprised when the rights reverted back to the estate for the last 25 years. Lucy Maud Montgomery's estate also had copyright revert to it, which they did exploit, but the publishers were left out in the cold. So it's something to think about. It's very quirky. What if you're a joint author? If you've done works jointly with someone, if you're a joint author, you can assign your percentage, your interest in the joint work to your beneficiaries. Of course, it'll pass, and you don't need the consent of the other authors. But the estate cannot exploit the joint work of authorship without the consent of the other authors or their executors. If your work can't be located, then it can be licensed for a fee by the Copyright Board of Canada. So the point here is that it's important to note where all your works are and your chain of title, because you wouldn't want your estate to miss out on that. We talked a little bit about, or you touched on a little bit, the issue of fair market value of artwork upon death, and I actually don't know the answers here. I think hopefully if you're asking for the answers from me, I actually don't know what they are. Basically, as I understand it, if you've been valuing your artwork at zero, pursuant to some rules which are there for your benefit during your lifetime, you're not going to pay tax on the value, any capital gain on the value of your artwork while you're alive. But upon death, the artwork is considered disposed at fair market value, and any capital gain on that artwork will be at the estate's expense. And I don't know how you get around that in terms of tax rules. And I don't know if Ben does either. So we're going to just go through some practical tips. And I know it's a lot, but feel free to interrupt me. And I think we're on slide 37, Gary. Keep going, keep going. Yeah. Okay, stop. Go back. There you are. Okay, So the first thing is identify which works attract copyright. You don't want your silly musings that nobody cares about to burden the executors. Get rid of them or deal with them separately. Secondly, decide which assets you wish to control. Identify them very specifically. Gather any paperwork, your chain of title, the location and number of known copies of your works, whether there have been written assignments or written licenses. Have you made any copyright registrations in any jurisdictions? Maybe put together a history of the exhibition of your works, if they're visual artworks, publications, recordings, or communications, just to help the estate decide whether there's value. Any contact information for collective societies, any contact information for the legal representatives of joint authors who may have died. They seem pretty obvious, but they may not be to you. And don't forget about your digital assets and providing usernames and passwords. Then you should decide, before you get to any of this, decide which works you want to destroy. Are there any works you want to withhold publication of for reasons of privacy or confidentiality, or defamation, or other sensitivity, and for how long? Margaret Atwood is really, really incensed about the short term of copyright in Canada after death, because she said there are many papers that she has that are just too sensitive to be published 50 years after her death, that they're either going to defame people or they'll breach confidentiality, and once they fall in the public domain, they will be, in fact, accessible. And she said that's going to mean that a lot of people, particularly politicians or people in public positions who have these kinds of materials, will destroy them. But you need to think about that too. Number 6, if you have any neighboring rights, I think you need to identify that. In terms of moral rights, do you wish to waive your moral rights in writing? Because you don't have to actually exercise moral rights, and you don't have to have your executors exercise them. And consider the reverse. Do you want to say, I don't want the estate to benefit commercially from my works if they associate my product with McDonald's or whatever? I mean, is there something that you really don't want to happen? You should state that intention. Do you want to make your works accessible on death, or not publish them until they fall into the public domain? Consider whether you want your executors to enforce the reversionary interest, if it's still law in Canada, or to give effect to any assignments you may have made already of your works to third parties. Then, in your will, address the issue, who will be the beneficiaries of your assets, including those which enjoy copyright, and also address who will be the executors of your overall estate and of your copyrighted assets. The Writers' Union suggests, and it's not always possible, that you have 2 executors, one for your general assets and a specific executor for your copyright, who can take the care of those assets that you would want to be shown, and to also exercise the moral rights on your behalf. And that's not always possible, but it is a good idea to think about it. And I think you need to consider providing instructions to your executors and to any corporations who may own your works and enjoy moral rights in them after your demise regarding your intentions, even if they're ignored. Lastly, also consider whether you want to have posthumous works published during the duration of copyright after you die. In closing, I'd say reflect on your best and worst case scenarios for your works and enable your executors to act in the best interests of the beneficiaries. And the beneficiaries may not be the executors, they may not be your children, or the executors may not be your children, the beneficiaries may be, and in a manner which reflects your intentions.
Is it possible for us to get copies of these wonderful books that you put up there?
Yes,
Give us the copies of the other, the gentlemen.
I didn't bring any, and I would like to just make a couple of little minor amendments. There's some typos in there, but Gary, can we get them to? I'll have this cleaned up and sent to you by email. Gary, yeah, I'm sure we can do that. Absolutely, I don't think it'll be a problem.
We can definitely make them available via email if you just make sure Sophia has your email address and notes it. But we'll also bring them next week for the final seminar.
Thank you very much.
All right, well, that was excellent. We still have a little bit of time, so I don't know if there were any more questions because I may have cut Ben off a little short. Does anyone have any other questions to ask
Yes,
Ben?
I do.
Yeah.
No, this would be to you, I think, darling.
Okay.
Neighboring rights, wouldn't that be status of the artist? Isn't that what we're talking about?
No, neighboring rights are just they're named that because they're rights that are neighboring on copyright, and they go to 3 classes, including performers. But in Canadian law, the only neighboring right we have presently is a neighboring right in a sound recording. So it's basically for musicians and singers. If there is a CD of a dramatic work, which could happen, a radio play, for example, that would enjoy the neighboring rights protection. And the neighboring rights collective is organized through ACTRA on the English side. There's actually, as we speak, there is in Geneva, there's an international conference which is attempting to arrive at a new international treaty for audiovisual performances. So this is the remaining piece of the artistic pie that is not yet covered in an international treaty. And so they're attempting to do that in Geneva this month. And if that succeeds, then that may act as a catalyst for Canada later on to adopt provisions regarding audiovisual performances. Recorded. It would have to be recorded. That's correct. Would be anything recorded. No, not necessarily. The Audiovisual Performances Treaty is about the audiovisual performers. In Canadian law, and this may soon be finalized. In Canadian law, the author of an audiovisual work is unclear. There are some who argue it's the scriptwriter, others who argue it's the director, and others who argue that it's the producer. So the authorship of audiovisual works in Canada is a little bit unclear. The writers and the directors have put forward a proposal that they should be considered the joint authors of audiovisual works. Yeah.
Is it sufficient to send a letter to yourself registered with your copyright? My understanding is that it is not, but
So the old trick about if you author a work and send yourself a copy of it by registered mail, don't open it unless and until there is a copyright issue. Is that sustainable in Canadian law?
As far as I know, it still is. I mean, the issue is one of evidence. You need to create evidence that you created the work on a certain date. And the problem is that sometimes people will put stuff out on the internet, and then it's other people start picking it up, and then you can't prove when you created it. So the technique of sending yourself a hard copy in a registered mail envelope actually is evidence. It shows the date. At least it shows some date. It went through some kind of third-party mechanism. And if it's unopened and sits in a lawyer's office as well, it's even better. But the idea is to use anything that will hold up in a court of law to show as evidence as to the date of creation. Because usually you end up in fights regarding who created that first, or who stole from who, or who copied. It may show that you actually. It may. You may want to put at the bottom, copyright that date. But it depends whether you could have fiddled with the actual computer record or tampered with it. So again, it's a question of, is that sufficient evidence that would hold up on a court? So it's always best to have some other mechanism. Giving a copy of it to perhaps a lawyer or a friend, or mailing it to them, and it would be extra backup. It's very hard with computer things because you're always changing your drafts. It may hold up, it may not. Yeah, again, it's using a third-party mechanism.
Yes, the Writers Guild of Canada has a script registration service for film and television scripts, and so that's a very wise investment just to register it with the Writers Guild. I don't believe the Writers Union of Canada has one for novels or other literary works.
Gary, what about the theater?
Pardon? Yes, the Playwrights Union of Canada also has a script registration service.
I mean, there's always registering copyright. You don't need to register your works that attract copyright with the Copyright Office, but if you can afford to do so, you can. It's a lot easier in Canada than it is elsewhere because it's less expensive and you don't have to deposit a copy of it. But if you're always changing things, the expense does add up. Copyright budget, the fee for copyright, it's around $50, I think, $40. I'm going to guess that it's somewhere under $50. When I used to do them, it was $10 and then it became $15. But I think it's probably increased in time, but I'm not actually sure what it is. But you can go online and just go to copy. You'd find it very quickly. It's supposed to be just a fee to cover admin expenses. So maybe it's in the $30 range. I really don't know, but it would add up if you're registering them.
All right. Thank you very much again to our speakers. It was an excellent session.